Be ready? Start. A document filed along with a miscellaneous application can at all be read as a part of record in the present first appeal filed under section 173 of the Motor Vehicle Act, particularly when the respondents have a right to file objection against the said application. Stop. In other words, where an additional paper is filled along with the miscellaneous application for disposal of interim relief application, can the document placed reliance upon by entertained as an additional evidence, and that too without there being a prayer by the appellant as per the provisions of Order 12 Rule 27, which is applicable to the appellate proceedings under the Motor Vehicle Act. Stop. The provisions of Order 12 Rule 27 are not applicable in the proceedings before the Motor Accident Claims Tribunal for the reason that an independent procedure under the Special Act and the rules framed thereunder is provided, but by virtue of Section 108 within bracket B of CPC, the provisions of CPC are made applicable to the present proceedings. Stop. Section 108 for ready reference is extracted below. Stop. Stanza. In this connection, it is also necessary to point out that character roll entries are recorded in annual confidential remarks of an employee by superior officer on the basis of appraisal of his work and conduct during the course of a year, who has opportunity to look into the work and conduct of employee, and such annual confidential remarks are further required to be approved by next higher authority as indicated in various government orders relating to the government employees issued from time to time, whereas the punishments awarded to a government employee are always based on disciplinary action taken against such government employee. Stop. Unless there is specific service rule regarding placement of the punishment in the service record, and the punishing authority in pursuance of such rules indicates that such punishment be placed in service record of employee, and further such punishment shall deprive the employee for a particular service benefits to be accrued during the course of employment of employee. In our considered opinion, in absence of such specific rule debarring an employee from any service benefits, such punishment cannot automatically deprive the service benefits to be accrued to the employee. Stop. Normally, under service rules applicable to the government employees of the state, the legal impact and implication of punishments afforded to them have been provided. Stop. Such as dismissal and removal from service debar the dismissed and removed employee from post-retirement benefits and certain civil rights on such dismissal, whereas the punishment of removal would not deprive removed government servant from other civil rights except depriving him from post-retirement dues and other service benefits. Stop. Likewise, reduction in rank does not debar an employee from future promotion and other service benefits like post-retirement dues. Stop. Similarly, stoppage of one increment for particular period debars the employee from financial benefit of said increment, which is otherwise liable to be added in his pay scale on account of accrual of such increment. Stop. If two increments of an employee with cumulative effect have been stopped, such employee will not get the financial benefits of two increments which may be otherwise admissible to him in his pay scale. Stop. Stanza. Thus, the legal impact and effect of stoppage of two annual increments with cumulative effect would be merely that the employee or officer would suffer loss in payment of his salary to the extent of denial of two increments which would be otherwise admissible to him, but for the said punishment he has been deprived of from said benefit of service stop. Thus, in the service jurisprudence, the employee who has been awarded punishment of stoppage of 2 increments would not lose the other benefits of service except the aforesaid financial loss in payment of salary stop. Therefore, in our considered opinion, the stoppage of 2 annual increments of the petitioner with cumulative effect cannot deprive him from other benefits of service, including his eligibility and entitlement for promotion to the next higher post if he is otherwise eligible and entitled for such promotion. Stop stanza. At this juncture, it would be useful to take a classic example of civil judge within bracket junior division who is punished by stoppage of 2 annual increments with cumulative effect in departmental inquiry at very inception of his service career within 3 or 4 years of his initial service, and he has to still serve the subordinate judiciary till attaining his age of superannuation for about more than 25 to 30 years stop. In case on account of such stoppage of 2 annual increments with cumulative effect, he would be debarred or deprived from his promotion on the next higher post of even civil judge within bracket senior division and further on the post of additional district judge and thereafter on the post of district judge. Then his entire service career would be run merely on account of said punishment. Stop stanza. The law is well settled that if a probationer does not satisfy the requirements of the employer, his services can be dispensed with by an order of discharge. But if in the order of discharge there is any imputation of misconduct which may have a bearing on the future employment of the probationer, an inquiry in the matter should be conducted and the probationer ought to be given an opportunity to defend himself. Stop. Though in the initial order of termination there is no imputation or any misconduct against the petitioner, in the subsequent order it has been elaborately recited that the foundation of the order of discharge is on account of financial irregularities committed by the petitioner. Stop. The subsequent order, which is now challenged, has the effect of casting a stigma on the petitioner, and therefore much persuasion is required for this court to hold that the authority should not have passed the order without affording a reasonable opportunity to the writ petitioner to defend himself of the charges levelled. Stop. Admittedly, no inquiry was held. Stop. That being the position, this court has no option but allow the writ petitioner and to interfere with the order dated 18/10/99. Stop. The writ petitioner shall now be reinstated in service and the authority will be at liberty to initiate a fresh proceeding against him in accordance with law. Stop. The question of the entitlement of the writ petitioner to any back wages will be considered by the authority in accordance such norms as may be in force. Stop stanza. The question whether the termination of service is simpliciter or punitive has been examined in several cases. Stop. An order of termination simpliciter passed during the period of probation has been generating undying debate. Stop. The recent 2 decisions of this court, after survey of most of the earlier decisions touching the question, observed as to when an order of termination can be treated as simpliciter and when it can be treated as punitive and when a stigma is said to be attached to an employee discharged during the period of probation stop. The learned counsel on either side referred to and relied on these decisions either in support of their respective contentions or to distinguish them for the purpose of application of the principles stated therein to the facts of the present case stop. After referring to various decisions, it was indicated as stop over.